Hi, how are you?
Good, how are you doing?
I'm doing well, thanks. Did you have any trouble logging on or anything?
I'll admit I practiced earlier today with someone that's more tech savvy than I.
That's okay. I love that. Dr. Shakir is joining.
Hey guys, it's Petrov. I don't know.
Oh, I can change your name.
Okay.
There we go.
Which one am I?
I just fixed it.
Okay, thank you.
There we go. Hi, Dr. Shacker. Oh. I'm not sure if you can hear us. So we'll just give it a couple minutes for everyone to log in, and then we'll kind of go over the logistics of everything quickly.
Hello.
Hello.
Hi, Aviana. Good evening.
Hi, how are you?
Good. How are you? How come I can't start video?
You just shared your screen.
All right, let me unshare.
It also doesn't allow
That's
me
not
to
my
use-
screen, Aviana. That's your screen or somebody else's screen. You there, Aviana?
Oh, sorry, I was muted.
Okay.
It says that there are two of you.
I don't understand that.
Did you possibly send your link to somebody else that might have used it to log in?
He sent it to me.
Oh, okay, just
You
you.
log in separately, but it should still be the Zoom thing. So yeah, I can log in and log out. Let me do that.
Hold on
Okay?
1 second. Let me
leave and log back in. Let me see
Okay.
that.
So Aviana, if you can, maybe you can, because somebody changed my name, but
Yep.
maybe it was you, but yeah, I'm using Dr. Shaker's invite, so maybe that's why.
That shouldn't make him not be able to.
You keep saying you cannot start your video because the host has stopped it.
I
And
have
same for me.
Same for you, Roman?
Yeah.
Okay.
We cannot start a video because the host has stopped it.
Try that now.
Well, apparently it's working now.
There we go.
There you go.
Sorry about that.
Aviana.
I'll get my white coat as well.
Hat. I was in the OR all day, so. Oh, Dr. Weeman is under my name, so maybe we need to send him a link. Is that Dr. Weeman?
Oh, I can
How are
change
you?
his name.
Okay.
Oh, is he not able to hear us?
I think this is what he meant to say.
I'll chat him.
Oh, there we go. Evening, gentlemen.
Good evening.
Yeah, he can't hear us.
Maybe forward him a new link and maybe we can just message him to use that. But I still don't understand why he's showing
It-
under my login name. It's strange.
If you sent him your panelist link, that would be why, because you each got your own panelist link.
Okay, I see. Okay, my bad. Okay.
But I can change his name. It's just a matter of him being able to hear us.
Okay.
I chatted to him and asked him to log out and back in. Now,
I emailed him.
okay.
Dr. Can you hear us?
Hmm?
I'm asking Dr. Weeman if he can hear us. It doesn't
Okay.
look. Okay, maybe now he did.
Yeah, it looks like he's logging back in, I think. So are
Did
you all going to be sharing?
Dr. Gardaki or Agent Gardaki? You have so many titles.
Mary is fine. We can keep it simple.
Okay.
Yeah.
And is it Attorney Cortez joining?
Yeah, he is. I spoke to him earlier today, and he was still good to go. I just texted him to see if he was having any problems logging in.
Okay. So we have Dr. Weeman, who was on and then logged off. He is, I'll introduce everyone as panelists before we start.
Okay.
He's an MD-JD and he's published some books on medical malpractice and so forth. But according to his bio, he's not practicing law, but I think it was a degree that he did to
Mhm.
augment what he's doing. And Dr. Petrov is a professor at UTMB in Galveston, Texas. And he also previously worked at Temple. There he is.
Hello.
And a friend of mine. And he's
Hello.
member of the Eastern Cardiothoracic Society and is worked in several roles.
Okay.
Thank you for your time. It's an honor to have you over in our meeting.
Oh, no, thank you for the invitation. I really appreciate it. At UTMB, do you interact with any of the PhDs doing hard science there or no?
Yes, I recently moved here, and actually yesterday we had a meeting where I got introduced to some of them.
Oh, really? So I was initially, before I became an FBI agent, at Wayne State University in Detroit, Michigan, and one of our professors in the department, actually, it's been a while, so almost 18 years ago, moved out to UTMB. Her name is Lisa L. Frank. In case you run into her, she does cell signaling at a molecular level, but yeah, small world.
Definitely, I'll look her up and I'll say hi.
How is the weather in Galveston?
It's beautiful.
Beautiful.
It's 72 degrees.
Oh, well, you know what? Don't be jealous. It was what, 50 today-ish in Jersey, gentlemen, right?
I've been indoors all day, so I wouldn't know.
You and me both. I peeked outside for a hot second though.
Sounds like Dr. Women doesn't hear us at all.
Oh no.
Dr. Women, do you hear us?
Hi, Attorney Cortez. Good to meet you. Thank you for joining us tonight.
You're welcome. How are you guys?
We're doing great. Thanks.
Good, good. Nice
I'll
to meet everyone.
email him.
So we have two other panelists, but it looks like Dr. Weeman is having audio issues and I am Huzaifa Shakir, and I had reached out to Mary through my connection with her through the MHA program at Rutgers. So again, thank you. Dr. Petrov on the screen here is a professor of thoracic surgery at UTMB in Galveston, hence his 72-degree weather, yeah, jealous, whatever you want to call it. And I'm a CT surgeon here at Rutgers in Newark, in New Jersey.
Cool. Pleasure to be introduced to all of you. Thank you for thanks for having us. You know, happy to chat with you all tonight.
I appreciate it. We'll see if we can give Dr. Weeman a few more minutes for this thing. Otherwise, when Aviana gives us the go-ahead, we'll start at 7. And I will introduce the two of you as our main speakers and Drs. Petrov and Weeman as panelists. Dr. Javed Farr may or may not join. I'm not sure what's happening, but we'll see.
Dr.
this is
Gerard
Daryl.
got stuck in a case.
This is Daryl. Can you hear me now?
Yes.
Yay.
All right.
Wait.
Perfect.
Hi, Dr. Weeman. How are you? Thank you for joining us.
Did we prevail over the technology finally?
So I will formally introduce everyone as panelists. Dr. Weeman, can you hear us?
I can hear you.
Okay, great.
Perfect.
So thank you everyone for agreeing to do this. Aviana, again, thank you for your help, your technical help.
Of course.
At 7, I just wanted to introduce the two panelists, Dr. Weeman, to Agent Gardaki and Attorney Cortez. Dr. Weeman is a retired professor of surgery with tenure at the University of Tennessee Health. And in Memphis, he was chief of surgery at the Veterans Affairs Medical Center in Memphis from 2009 to 2015. And he was responsible for the VA surgical services in Tennessee, Kentucky, and the western half of West Virginia. He's board certified in both thoracic surgery and surgery. He's the author of 2 books, Medical Malpractice and Fundamental Issues in Healthcare Law, Facts for the Healthcare Professional. He's also been a contributor for the Huffington Post, wrote on many healthcare law and policy issues, and has many publications in this area. So thank you, Dr. Weeman. Dr. Petrov was introduced earlier. He's again a professor of thoracic surgery at UTMB and chief of thoracic surgery at UTMB in Galveston. Previously, he was in Temple in Philadelphia. He has many areas of expertise, including lung and esophageal cancer, benign pathologies of the chest, foregut. He does complicated things like POEM, which is poor oral endoscopic myotomy for patients with reflux disease. And he's also an executive member at the Eastern Society. So, and to our 2 panelists, we have two great speakers, and I'll introduce them first, and then I'll introduce the panelists, and then we'll get started. So thank you so much for everybody coming in today. I appreciate it. We're almost ready to start.
Thank you, Dr. Shaker. It's an honor to be here.
So yeah, once the clock hits 7, I will open up the webinar so everyone can join. We'll give it like 2 minutes just so that people can file in and make sure they can hear, as we all saw is sometimes an issue. And then I'll just give you all the go ahead and we can get started. And just so you know, the meeting's being recorded. It'll say that once we let everybody in, you'll hear it. The voice of God, I like to say.
Just for information, it's Wyman.
Wyman.
Okay.
Like the furniture cream.
Thank you.
Two elective cases today, and both were canceled because of a type A dissection with ruptured aorta. So that changes everything.
All right, it's 7 o'clock. Everyone okay if I open it up?
Yep.
All
Let's
right.
go.
Sure, I'm here.
And I'll ask everyone to mute when the speakers are speaking, if that's okay, just to eliminate background and echo noise. Thanks.
We'll just give it a couple minutes for attendees to flow in.
Yeah. And we'll have a chat function, Aviana, that we can, the panelists can monitor.
Yep, so you'll have the Q&A function down below and the chat function. So just be sure to check on both of those because people will use either or.
Okay.
Just because in the Q&A, people can ask anonymous questions and in chat they can't. I don't know if anybody has something sneaky they want to ask.
And we're scheduled to go from 7 to 8 essentially with the talk, and then a 15 to 20-minute Q&A roughly, right?
Yep.
Everybody okay with that?
Mhm.
Okay, thanks so much.
All right, we'll just give it a couple more minutes and then we can get started.
Wyman or Dr. Wyman? I'm sorry,
Wyman.
Wyman, okay.
Mm.
Ready, Aviana?
You are all set to get started.
Okay. Good evening. My name is Dr. Huzaifa Shakir. Thank you for joining the Eastern Cardiothoracic Surgical Society Standard and Ethics Committee meeting this year. This is our second meeting of the Standards and Ethics meeting during the calendar year. And we have a really special webinar today entitled Healthcare Fraud and Abuse, Rights of the Whistleblower. And we are really honored to have this presentation today by FBI Special Agent Mary Gardocki and U.S. Attorney Lee Cortez. Attorney Lee Cortez is the Executive Assistant United States Attorney. Before his recent promotion to that role, he served for 2 years as Chief of the Healthcare Fraud Unit and for 2 years as Deputy Chief of the Special Prosecutions Division, overseeing public corruption matters. He also served as an Assistant U.S. Attorney in the Special Prosecutions Division and the Criminal Division. Before joining the office in 2010, he served as an associate at an international law firm in New York City. He's a JD from Fordham Law School and his BA from King's College. Special Agent Mary Gardocki is a special agent with the Federal Bureau of Investigation, FBI, assigned to the Newark Division Field Office. For the last 18 years, she has been assigned to squads that investigate healthcare fraud and drug diversion matters. Before graduating from the FBI Training Academy in Quantico, Virginia, she received her PhD in molecular genetics and chemistry, her MA in biology, and her BS in biological sciences, biology, chemistry, and physics from Wayne State University. We're really honored to have these two excellent and unique presenters today for our cardiothoracic community. We're also honored to have two guest panelists in addition to our speakers, Dr. Wyman and Dr. Roman Petrov. Dr. Daryl Wyman is a retired professor of surgery with tenure at the University of Tennessee Health Science Center in Memphis. He was chief of surgery at the Veterans Affairs Medical Center in Memphis. From 2009 to 2015, Dr. Wyman was the Veterans Integrated Service Network chief surgical consultant, where he was responsible for the VA Affairs surgical services for Tennessee, Kentucky, and the western half of West Virginia. He is board certified in both thoracic surgery and surgery. He has published numerous articles and book chapters, notably a book entitled Medical Malpractice, A Physician's Guide to Navigating the Minefield of Medical Malpractice Law, and another book, Fundamental Issues in Healthcare Law, Facts for the Healthcare Professional. The other panelists today, we are honored to have Dr. Roman Petrov. He's Chief and Professor of Thoracic Surgery at UTMB in Galveston, Texas. Dr. Petrov is a cardiothoracic surgeon with special expertise in thoracic oncology. He's focused on treating patients with lung and esophageal cancer, as well as aspects of benign pathology in the chest and foregut. Dr. Petrov's clinical interests lie in the field of minimally invasive and robotic surgery and advanced surgical endoscopy. I'm honored to have everyone here tonight talk about this unique issue in our community. And without further ado, we'll let our presenters take it away. We'll be monitoring the chat for questions, and we'll do our best to get to everybody's thoughts and interest in this thought-provoking lecture. Thanks.
All right, thank you, everybody, and thank you, and we appreciate the invitation to come and present to you today. Again, my name is Lee Cortez. I'm the Executive Assistant United States Attorney here at the U.S. Attorney's Office for the District of New Jersey. So I'm the federal law enforcement representative. My office handles all federal criminal prosecutions that are done in the District of New Jersey. The one note that I give is I'm going to be speaking about our office and some of the work that we do. All the opinions that I present today are done on my own behalf and are not necessarily representations of the positions of the Department of Justice. So just have to give out that necessary clarification, and then I'll pitch it over to my partner on the presentation, Agent Gardaki.
Evening. Thank you again for inviting us here to speak to y'all this evening. And to take it one step further from what Lee just articulated, is that we cannot offer any legal advice either. And that's coming from the non-attorney in the group.
All right, so I think what Agent Gardaki and I had, we're mindful of kind of the topic about whistleblowers, and that's going to be a part of our presentation. But I think, for a lot of you, and for folks who don't, who aren't in the criminal realm like Mary and I are on a day-to-day basis, we figured just to kind of step back and give you kind of a sense of who we are, what we do, and what we care about. So we'll step into that. But of course, if Dr. Wyman, Dr. Petrov, Dr. Shakir, if you guys have questions at any point, or anybody watching has questions for us, we're happy to engage in a back and forth at any point. So please feel free to fire away, and that could give us a break from talking at you all. So we appreciate the dynamic participation of everybody. So I'm going to share my screen because we prepared some slides a bit. So if I can get this to work, you guys will be able to see some of what I am presenting. Mary, you can just holler at me if it's not working at all. Give me a thumbs up if we're showing. All right, great. So just to kind of give folks an orientation about federal enforcement that the FBI and the U.S. Attorney's Office and other partner agencies do. We operate, we operate and enforce statutes that do both civil and criminal work. So, and some of our partner agencies can include the alphabet soup that's listed up here. So the U.S. Attorney's Office, the Department of Justice has different components located in Washington that do healthcare enforcement work. There's the FBI, and then there are other agencies that, you know, have criminal enforcement wings, like Health and Human Services has an Office of Inspector General that we partner with quite a bit, as does the FDA. And then these other agencies that are listed here also do criminal and civil enforcement work in this area. We enforce a number of different statutes, some of which have criminal ties and some of which are civil. So the first claim here that's listed is probably our number one civil enforcement tool, the False Claims Act. And what this means is if a claim is made to a federal health insurance payer like Medicare or TRICARE or Medicaid, and it is false in some way, then that claim is fraudulent in the government's eyes, and we can enforce that civilly. And you know, the big ticket is that the government can seek triple the amount of damages for each claim that was paid. And so this is a pretty important enforcement tool for the government. So, you know, because, you know, any claim for reimbursement made to Medicare, we can seek not only the repayment of that, but we can seek it ×3. So the numbers, as most folk, you know, given the amount of money that's in the healthcare system, those numbers can add up fairly quickly. And so this is a pretty important enforcement tool for the government. In the remaining of these statutes, most of them have criminal components. And so, you know, the two that I want to highlight that are the most important for us are the anti-kickback statute, which covers, you know, the payment or giving of remuneration to, you know, focusing on this population, healthcare professionals, to taint or affect or influence the care treatment of patients. So it is a pretty important enforcement tool. It has both a criminal prong and a civil prong. If there is a kickback and that taints a claim for payment, then that becomes a civil issue as well, because the claim made to the government is therefore tainted and would need to, and the government can seek repayment of that, and again, triple damages. And then there's the healthcare fraud statute, which, you know, if there is a scheme to defraud a federal payer, if there are effectively lies told, you know, fraud is just a way of communicating a lie. So if a lie is told to a federal payer, and it was done on purpose, for, you know, that is potentially a healthcare fraud, and that again is something where we could see federal criminal charges on. So those are really kind of the tools that you know, Agent Gardaki and I think about on a day-to-day basis. As you know, as a prosecutor and as a federal agent, we really are not policymakers. We're not regulators. That's left to, you know, the members of Congress, the professionals at Health and Human Services, and at, you know, state medical boards. We are seeking, you know, people who have, you know, violated the law, and generally speaking have done so with a specific intent to violate the law, to, you know, corrupt medical decision making, or to obtain money for themselves, to which they are not entitled. And so that's really the framework for us, as opposed to kind of seeking to influence any kind of policy.
And just like any entity, we have finite resources, right? So oftentimes we're asked questions about, well, you know, like maybe I just made a mistake, right? Or, you know, it was an honest mistake. And so what we like to try and explain, and it's applicable in all facets of life, you know, whether or not your kid took the last cookie from the cookie jar right before dinner, right? And you're trying to get to the bottom of it, or in choices that we make as adults and in our professional lives is that, did you know what you did at the time that you were doing it, right? Did you intend to do it? And then were you aware of what you were doing and in full decision-making ability at that time? So knowledge and intent are two huge prongs that we are concerned about when we look at healthcare fraud type investigations. The other thing, it's just to piggyback on what Lee has already started to talk about, is we have very finite resources. But we're very concerned about healthcare fraud investigations because we're interested in making certain that different areas of the healthcare provider arena is actually doing things in the best interest of the patient, right? And not because there is some type of ulterior motive or motivation running in the background because there's a financial incentive or some other reason at play.
So going to, so focusing in on New Jersey, because that's where Mary and I operate. Mary's right that, we have really only a limited number of resources. So at the U.S. Attorney's Office, we have, something on the order of about 14, assistant United States attorneys, so federal prosecutors who work in the healthcare fraud space. Now that's a lot. The U.S. Attorney's Office has only about 160 assistant U.S. attorneys, so we have a fair number of federal prosecutors working in this area. But it does mean that their time is precious. That still is, though, by and large, a very significant dedication of resources in this area. And for us, it matters a lot because, New Jersey is a very densely populated state, got a very significant healthcare costs. We have a significant population of senior citizens, large number of hospitals and nursing homes, the like. And we have a large population of pharmaceutical companies, device manufacturers. We really have, you name it, we have it here in New Jersey. And so, we have there's a significant amount of healthcare costs in the state, and we try to match that with a very significant amount of enforcement resources here in the state. It is and remains a priority for both my office and Mary's. And we remain very, very active in this area. But as Mary was talking about, though we have these resources, we do devote a lot of time to it. And this next slide is just an overview of the U.S. Attorney's Office. So, we spend a lot of time thinking about these cases and working to develop them. And so, now we've talked a little bit about the, kind of who we are, what we're interested in. Just now we want to talk about how cases come in. And so let me tee that up for Mary.
Thanks, Lee. Cases that we evaluate and take and work in this model that we've just sort of described, that involves partnership with the U.S. Attorney's Office and the Assistant United States Attorneys, the government prosecutors that end up prosecuting these matters, along with our partners at the different federal agencies. So we get information from a variety of different ways. We have folks that make voluntary self-disclosures. So that could be either an individual or a corporation. And simply that is just someone recognizes that they did something wrong, either civilly or raising to the level of a criminal bar, and comes in and wants to try and get ahead of it, minimize their exposure by saying, hey, this is who I am, this is what I did, and let the cards fall where the cards fall, right? The second way that we obtain our cases is through whistleblower or key tam filings. We like to also refer to this as relators. So with that being said, that is someone that has intimate knowledge of an activity going on that is costing the government money, right? It is types of fraud, waste, and abuse that is either at a civil or a criminal level. And what happens is this individual with intimate knowledge. So that means that it's not someone in the scrub room overhears a conversation by Dr. Sally and Dr. Ned that at the hospital that they were just at doing a case, they overheard someone say X, Y, and Z. Right? That's not what a relator or whistleblower is. This is someone that's either directly observing an activity, is being told to do an activity, is aware of an activity either going on at their company, hospital, or office, and they report that to the government. They will go to a law firm, engage in dialogue with that law firm. That will then prepare a statement with supporting documents that's then presented to the government in both DC and in the District of New Jersey. And from there, there will be what is typically referred to as a relator interview that occurs where that person, that whistleblower, comes in and tells their story. And we have a chance to discuss that, ask them follow-up questions, and then make a determination if the government is going to adopt that investigation or not. Another way that we initiate cases is through data mining, right? How do individuals compare against their peer group in their immediate area, in the state, in a geographic region, and through the country? And if you're an outlier, right, you are, I don't know, 50 times higher than the next person down in that specific type of billing, perhaps, or that service being provided, then that could be a way that a case could be originated and begun, just to determine what if anything is going on. Outreach from and referrals from all stakeholders. So this is where y'all come into play, right? You are on the front lines of what is going on in this specific field of healthcare. So folks like you who are in hospitals, in the community, and have knowledge of what's going on, folks that have the courage to say, either whisper or to come out and approach law enforcement and say, hey, you know what? There's something going on either within my group or in another group or within my hospital, right? To sort of self-police. In the whole adage of the New York Police Department, if you see something, say something. So don't discount or discredit that. That's very powerful information that we receive on the federal law enforcement level. Additionally, stakeholders could also include our counterparts from Mafukus or from commercial insurance companies. They might be seeing something on their end of things that they will then turn around and relay to us through their referral process. Oftentimes when one federal agency gets some information it might be applicable to other federal agencies. And so we will also get referrals from our law enforcement partners. And last but not least is sometimes our cases are generated from press stories that we also see in online or in a different type of news media. So they come from a variety of different ways, but they all are significant to us and important.
So I want to build on some of the things that Mary was just talking about, particularly with respect to the whistleblowers and key TAM filings, just from the government lawyer's perspective. So Agent Gardaki is completely right that some of our cases and that are brought to us, we rely on whistleblowers filing a lawsuit in district court, in federal district court, that gets sealed up, and only the government learns of the lawsuit once it's filed. And not to get too deep in the weeds here, but the reason that the lawsuit gets filed is because the law allows a whistleblower to file it. And what that does is it gives them the ability to obtain an ultimate percentage of any money that the government obtains. So it's not all just there's a significant financial incentive here. It's not all just about doing the right thing. But why that works is because it allows the person a share in the potential recovery in exchange for effectively sticking their neck out. Because although the lawsuit gets sealed and only the government knows about it at the time, ultimately long down the road, at some point, the whistleblower's identity is going to become known because these cases do not remain sealed forever. And while there are things that protect that would guard against retaliation, and I don't want to get too deep here because I can't stray into the legal advice component, and there are whistleblower attorneys out there who would do that, who would represent the whistleblowers and handle those aspects. It's a very powerful tool because it allows somebody who has seen wrongdoing, who knows about it from the inside and has witnessed these things and potentially has the ability to identify documents or identify witnesses, the types of things that lawyers and investigators like Agent Gardaki and I use to build a case that could potentially lead to a financial recovery. Right? Because just because there's an allegation doesn't mean that a lawyer can go prove it. And so it is the whistleblower who, can identify the wrongdoing, and just as importantly, can lead evidence that can lead to the recovery. So that's a pretty important role here in terms of the whistleblower's function in the cases that we work on. The cases can lead to both civil recoveries and from our point of view, criminal prosecutions, because if you learn about a scheme where there's kickbacks going on or healthcare fraud going on, that again can lead to individual charges. So I think that's a very important component of how our cases originate. Another thing, another aspect of it is a whistleblower's we do get lots of cases that come in from whistleblower filings. We can't do them all. And so when we assess them, we have to think about what's a better, is this a good enough case for us to devote our resources to it? And so having, someone who has inside information is very, very helpful. It's also important that the whistleblower made their concerns known to the company, right? Or to the right. So if let's say it's a physician, and there's physician becomes aware of potential kickbacks that are being paid by a company, like for example, like fancy dinners, or to influence a decision making, or that there's some sort of upcoding going on. If the insider has, that doctor has gone to management at the institution and made their concerns known, and nothing has changed or been rebuffed, from the point of view of the lawyer, of the prosecutor evaluating that case, that is a more compelling case because the concerns were made known to potential leadership and that conduct was not stopped. And so, as Agent Gardaki was talking about, a lot of these cases come down to intent. Was the intent to provide kickbacks to influence medical decision making? Was the intent to obtain more money or more payments from the Medicare system to which the entity was not entitled, right? And so those kind of steps by the whistleblower are important, which again makes it a more compelling thing for law enforcement. So Dr. Shakir, we got a raised hand.
You mentioned an interesting point, Attorney Cortez. You talked about the division taking cases more seriously if a whistleblower approached the company, the organization. I imagine there's a lot of anonymity involved, and that's fear of retaliation and so forth. And I know maybe you'll talk about rights later on, but how does that weigh on you as an attorney looking into the case when somebody has that concern, or that fear? From what I heard, it sounds like that you're taking cases that more seriously than where a whistleblower actually makes him or herself known. Can you comment on that?
So I think it's not about, and Daryl, Dr. Wyman, did you want to talk before I answer this, or are you going to let me go after?
You answer that, and then I'll have a question for you too.
All right. So I think it's not really when I'm it's a little bit of a different hats. I'm not a private attorney, right? I work for the government, and so I don't advise the whistleblower about all the protections that they can have. It's not in my, by the time it gets to me, right? The whistleblower has consulted a private attorney who represents whistleblowers, filed a lawsuit, and has chosen to bring it to the government. And so that's when it's coming to my plate. I don't advise that the whistleblower beforehand. There's not we can make efforts to and we don't knowingly out a whistleblower once the case is brought to us. That is, we don't even, when we're investigating, we don't even tell who we're investigating how the case started, right? Like that's not, the case from our perspective is sealed. And so we don't, we take great steps to keep the identity of the whistleblower and the fact that a lawsuit was even filed confidential. However, at the end of the day, if there ever is a resolution, it's going to become public. So Mary, did you want?
Yeah. So that whistleblower, prior to perhaps filing a key tam, maybe expressed their concern with a certain practice at their institution, and each institution does things very differently, right? Some have anonymous situations set up where people can provide information about a concern at that entity, right? So keeping a record as a whistleblower, hey, on this day, I expressed through the channels available to me, whether they are anonymous or some other type of system individually set up, right? I expressed this to someone. I did it in writing, I did it verbally, that type of thing. That's something that is would be of interest to us and in the filed key tam. And then also one follow-up, I apologize, is that the first time someone does something, right, anyone could make a mistake, right? I think everyone can agree with that. The second time it happens, right? Perhaps someone was confused as to what was occurring or what they were doing. When you do it, I don't know, 500 times or 3,000 times, then that becomes a concern for us.
Yeah, I think Mary hit, I think Agent Gardaki hit that, right? Like when, the reason it's important, to us in evaluating a case that a whistleblower brought it to the attention of somebody, directly or indirect, like confidentially, anonymously, however, and then nothing happened. Like it just, from our point of view, makes it a better case, right? A better case. You've got more solid intent if a decision maker at the institution learns of the concern and didn't take steps to address or correct it. I mean, from our point of view, that's great. That's great evidence. It bolsters the credibility of the whistleblower, and so it makes it a more compelling case. All right, Dr. Wyman, what do you got?
I'd like to, first of all, give the disclaimer, even though I am a lawyer, i.e. I am licensed to practice law in the state of Tennessee. I passed the bar exam. I make my living as a cardiothoracic surgeon still. But I would like to make some comments about whistleblowers and their protections. Filing a key Tom lawsuit is very complicated. The procedures are very different from filing a lawsuit just in a court for whatever reason. The procedures are different, and as such, you need to get a lawyer who is familiar with whistleblower key Tom type lawsuits. For example, as Mr. Cortez and Agent Gardaki mentioned, it has to be filed under seal. What that means is the case is not known to the potential defendant for a period of at least 60 days. The government knows, and you know. The government then has a potential of joining the case, in which case they will help in the litigation, but the whistleblower potential reward, if there's a reward at the end of the tunnel, is going to be between 10 and 15% of the recovery. If the government decides not to enter the case, the whistleblower can continue with the case, but their potential recovery then goes between 15 and 30% of the recovery. In 2020, over $2.2 billion were recovered under the False Claims Act federal. When you file a key Tom lawsuit, though, as a whistleblower, you got to be cognizant of the fact that many other laws will be pulled in on these types of cases. There's the anti-kickback statutes. There are the Stark laws for anti-self-referrals. Very often the states have their own False Claims Act, and even some municipalities like New York City, Philadelphia, Miami-Dade County, they have their own False Claims Act statutes. So it's important that you get an attorney who is familiar with this, because it's going to get very complicated. Now, what's going to happen? It used to be that the whistleblower was protected with whistleblower statute protections. You can't be dismissed, you're going to get your salary back, et cetera, et cetera. But what has happened over the years is that now, when you become an employee of a healthcare provider like the hospital or a group, there's a clause in your contract that states that if you do notice something that's unusual and it needs to be reported as possible fraud, you are obligated under your employment contract to first go to your employer so that they have the opportunity first to fix the problem. You can't just bypass them, because what's going to happen if you bypass them and they fire you, which they will, their argument is going to be that you breached the contract. They're going to say they fired you for breach of contract, not because you're a whistleblower. And you don't want to get involved in that can of worms. You're going to be in trouble. So if you're going to do it, get a lawyer who knows what the hell they're doing and follow his advice.
That's well
I'll
said.
comment on other things later.
That's well said. All right, Dr. Petrov, what do you got? You also have a raised hand.
Thank you very much. Absolutely fantastic presentations. Have a couple of questions. One for Attorney Cortez. So you said that government can recover triple the amount of fraudulent or error payments. Is it always triple amount, or is it sort of a
No, so
and how it is decided, the amount?
So, so it is not always triple. So, you know, so triple is maximum, is the most you can recover, along with penalties, you know, that a court could award. Now, the fact that it's triple almost anticipates that you've gone to trial, and that the court has awarded those damages. Most of these cases, most whistleblower cases that are, you know, where the government has decided to intervene and there's a resulting settlement. Most of those cases settle for less of a multiplier. Usually it is around double the amount of the claims. That is kind of a fairly standard benchmark in these cases. So whatever the amount of claims were, the claims were to Medicare or Medicaid, TRICARE, you double the amount of claims, and that is the settlement amount. The government never settles for just the amount that the government was out, because that's, you know, that just means that you're paying back the amount of money, and that's not worth, you know, that again, that's not worth the time, and that's not where deter, you know, for us, we're seeking, you know, to deter others from engaging in similar conduct. So that is you know, that is usually where these cases end up at double damage, you know, double the amount of the claims. And then as Dr. Wyman pointed out, you know, most of that money goes back to the government, right? So you get, the government is made whole, and there's a portion of damages that the government gets, but then there's a significant portion that goes to the whistleblower. And there, you know, and there's all sorts of things about you know, the whistleblower's attorney's fees that get worked out as well. So that is how a lot of the settlement dynamics work. But obviously these, you know, given the amount of how much money is involved in the number of in these claims, we can talk about, you get into real money, as Dr. Wyman pointed out. You know, the government recovered, you know, over $2 billion in False Claims Act settlements last year, which is consistent, you know, year after year. And many of these cases are brought to the government by whistleblower lawsuits.
My other question is, Agent Gardaki mentioned that if people sort of realize that they made a mistake and they self-report, does that have sort of impact on the payout amount and in settlements? If someone realized they made a mistake, how quick they need to report, and is there any real financial benefit in decreasing of the penalties that they will be facing?
I think that is that's handled on an individual case-by-case basis. Do you want to speak further on that?
I'm sorry, I missed it. Can you repeat that one?
Yeah, so if I understand it correctly, Dr. Petrov, you were asking if someone self-reports, is that somehow beneficial in limiting their exposure and the amounts of money that they may or may not be assessed and have to pay back? Is that correct?
Yeah, I think when there's a self report, I mean, I think it, you know, that we factor in, and there's, you know, all sorts of leniency. You know, there are a lot that goes into that. Like, you know, obviously, you know, if there's self-disclosure, you know, the Department of Justice is very interested in incentivizing those who have run afoul of you know, and have discovered these issues from doing that. We want to, you know, if you come to us, we want to reward that, as opposed to us coming to you. Then we're you know, many companies, you know, once confronted by a government investigation, decide to cooperate. but they're differently situated from our point of view that from those who come to the government and say, we found this issue, we want to remedy it, please, can we do that? Can we do that? How can we do that? The government is looking to incentivize folks to do that. So that is a pretty significant priority for us. It's going to require, repayment of the money. It's likely going to require still some sort of more than that, more than just, hey, put it back and we're all good. But that is, it's going to depend on the facts, right? If, what was discovered was not, pretty rampant, criminality, that, then the government is going to, is still going to want to assess what happened there. And there are other options, right? If what was discovered is something that resulted in harm to patients, right? So we're not just talking about money. That too is a pretty, from our perspective, is a pretty significant game changer, right? If patient safety is ever implicated, now we're talking more than just money, right? Now we're very obviously we're in, part of our job is to protect the public fisc, but we're also, the most important thing is always going to be safety.
And my last question, I'm sorry, Dr. Wyman, go ahead.
You go ahead, because Lee's not going to like me after what I have to say.
But we'll keep it to that. I think my last question, what is the personal responsibility of the physicians, and particularly employed physicians, if there is any irregularities with the billing of government for services? I mean, I'm sorry, like right now, my billers sort of reach out to me in my new practice and they sort of show how they bill and ask my opinion, and I like it. But in some of my previous practices, I had no idea who they were and what they were billing. So if in that scenario, some irregularities discovered because the billing occurs on behalf of the physician, what is the physician's responsibility if someone who is unfamiliar was billing on their behalf without any input and control?
Well, it's important to read the fine lines, right? When you sign up for Medicare or to treat folks with different types of commercial insurances, right? To read the fine lines. What does it actually really mean when you are you're submitting a claim to that insurance company for reimbursement? What are you saying? You most likely are saying and attesting to the fact, right? Although sometimes we don't think about it because it happens so routinely, is that I am licensed and qualified to be able to provide that service in the state, and that I have a true doctor-patient relationship with this individual, and that it's medically necessary are typically three things, right, that you would look for. That being said, it's important to understand, at least at some level, how billing occurs, right? And that if you see any type of questionable activity or you have concerns about something, that you do your due diligence then, even if billing is done on your behalf, to try and figure out what is going on. Dr. Wyman, would you like to add to that?
Yeah, I think I would.
Okay.
Under the False Claims Act, it's not just a tripling of the damages. Each false claim, i.e. each bill that is deemed to be fraudulent, also has a penalty of $11,000. So let's just say, for the sake of argument, you've got 1,000 bills, and that's a small number when you look at a hospital or a healthcare facility. 1,000 bills that are false, each one, besides the treble damages of the bill itself, you have the other penalty of $11,000. Now you're talking at least $11 million in penalties, and it's usually much higher than that. And now I'm going to direct a question to Mr. Cortez, because it seems in the literature that the Department of Justice has a willingness to accept settlements in these healthcare type fraud cases. And these settlements include that the defendant does not admit any wrongdoing, and as such, they pay a penalty and they admit no wrongdoing. And the criticism of the Department of Justice for doing this is that one of the intents of the False Claims Act, which you mentioned, was to act as a deterrence. But if you do this with no admission of guilt as such, then it seems to me that the people that are paying these settlements are paying as a cost of doing business, and they're not saying that they did anything wrong. So your whole deterrence aspect is really going out the window, because what you should do is have them admit guilt, because it's a breach of the public trust. What do you have to say about that?
So a few things. One, I think, your ending point kind of captures a little bit of my response, because you said admit guilt, and you're just mixing up the criminal system with the civil.
I should have said admit liability. I'm sorry, I shouldn't have used guilt.
Oh,
I should say
that's all
admit
good.
liability.
But in the criminal system, an admission of guilt is a necessary predicate to entering a guilty plea. And that is, and because that is something where you are facing prison, right? You are facing the specific sanction of being, sent to imprisonment. And so that is a necessary part of that system. The civil system is a little bit different, right? The goal here, when it really boils down to it, yes, you want to affect change, but in civil litigation, when you say, how you say I'm sorry is paying money. Like, this is, when to get pretty baseline about, this is America. That's how you say I'm sorry. That's how you say I'm sorry in the civil liability piece. So now, that's not to kind of throw water on, the fact that there are admissions. Like, admissions are very important. There are some, areas, there are some state enforcement authorities that require admissions of responsibility. From a legal perspective, when you're defending these civil cases, if you make admissions in there, you are, and you don't have, there's no criminal component, so you're not required in a criminal resolution to admit responsibility. In just the civil system, you make admissions, you are now opening yourself up to other lawsuits. If you're a publicly traded company, now you're going to get sued by the shareholders, and the case is done because you've made an admission already. And so, from an enforcement perspective, seeking admissions in these cases, I think, is challenging when it comes to it, and I think that a lot goes into it on both sides. When what you are actually seeking, like the redress that you are seeking, is the money, and the money in many ways is the effective admission of liability. Like, a company can say, look, we're not admitting to anything, but when you're paying, several $100 million to the government to resolve these allegations, I really think that rings hollow. And so, to kind of just bat it back a little bit, I think that it's just a little bit more complicated than, undermining kind of the purpose of living up to what the statute wants to get.
Fair enough. One other point that I'd like to make, since we're talking about protections for the whistleblower here, is if you do get hit as a whistleblower with retaliation, you have 3 years under the statute of limitations to bring a lawsuit against the retaliation. And that 3 years the clock starts clicking or ticking when the action happens. And there was a recent case out of my circuit, the Sixth Circuit, because I'm in Tennessee, where a whistleblower had his privileges and his ability to work at a hospital. It stopped on say September 1st, 2016. And he got the letter notifying him that he was fired on September 27th, 2016. He filed the retaliatory lawsuit on September 27th, 3 years later. In other words, it was within the statute of limitations from the time he was noticed, but it was beyond the statute of limitations from the time that the action occurred. And in my circuit, his retaliatory claim was thrown out because he was beyond the statute of limitations. And the court said that it is very clear that the clock starts ticking on the statute of limitations when the action of retaliation occurred, which was when the clinical executive board of that hospital did the vote. So if you're going to bring one of these suits, be very careful that you bring it within the statute of limitations, and each circuit might be different. So be careful with that.
Just to follow up related to whistleblowers and key TAMs being filed that several people touched upon is that these types of lawsuits, right, of that folks can bring with intimate knowledge of some type of activity occurring, that they happen under seal, right? What that means is that they're not disclosed to anyone. However, that whistleblower, that relator, should not be articulating to everyone and their friends, right? That, hey, I filed a key TAM against, X, Y, and Z, right? The secrecy of it while the government investigates, if the government adopts that investigation, it's only as good as the confidentiality that each individual involved in the process keeps it.
I saw you unshared some of your slides, Attorney Cortez. If we have a couple of minutes, we'd love to maybe see a snippet of that. And we really appreciate sort of the back and forth that we were able to engage in.
Sure. I mean, let me put it back up. Let's see.
Do you want to just go over some of the trends that we're sort of seeing both in New Jersey and nationally?
Yeah, I mean, do you want me to put it up, Mary, or you want to just go over them?
We can put it up. Why not?
Hold on. So I'm gonna give me 1 sec. Give me 1 second. I'll put this up.
Okay.
Okay. There we go. Okay, you guys should see this now. Hopefully can you see these?
Yeah.
Okay.
These are some of the things that have kept both Lee and myself, along with our colleagues in the District of New Jersey and throughout the U.S., very busy the last several years. Some of which would be particularly important to y'all, some a little bit less so. We've already talked about kickback cases a little bit, and as well as some of the larger types of fraud. However, with kickback cases, there's that quid pro quo, right? You are getting something in return for something. And sometimes it's very difficult to sort of distinguish that. With speaker programs as well, right? That's something that some physicians really aren't tracking on. that there might be some difficulty, or there might be some exposure there for them. Right. So a company invites you in, right? There's a speaker, or you're asked to speak to an assembled group at a restaurant. Really, what does that mean for you? And you know, the questions that should be going through your mind, right, is that do I have some exposure there as well? With regard to prescription drug related offenses, specifically, if y'all are writing still hard copy prescriptions, even if it's occasionally, you need to keep in the back of your mind that those prescriptions can be washed, right? So what you write there is not necessarily what ends up at a pharmacy being filled, because someone can take a few relatively simple steps and change that prescription to something that they are after a little bit more, right? And one way that you can protect yourself from that is simply by changing the type of pen that you write with. So if you utilize a marker-based pen, that marker will absorb into the paper and leave a shadow as just an extra level of protection. And then let's see, we touched upon billing. Important, right? Is something not looking right related to, are you charging additional for services, right? Or is something being charged for a service or procedure that's not being rendered? Lee, do you want to touch upon a couple of them in our last couple of minutes?
I do. So the kickbacks are the ones that I touch on in particular for this audience. The anti-kickback statute is very broad. It's a very broad government enforcement tool. It's a one-way statute. So you don't actually have to, the person getting the remuneration doesn't actually have to agree to do anything. The intent of the giver, if they're seeking to influence a doctor's decision making, they've violated the anti-kickback statute. It also works the other way. If in receiving the payment, the recipient of it, let's use the doctor example again, is receiving it, and with the intention to be influenced, that too, violation of the anti-kickback statute. And again, remuneration is the word used in the anti-kickback statute. It's a pretty broad term, and it's been held to mean a lot of different things that wouldn't necessarily occur. It doesn't just cover, like, we're not just, I spent a lot of time in the public corruption world. We're not just talking about envelopes full of cash here. Things that have been found to be improper remuneration in the anti-kickback statute are pretty broad. Speaker program payments, consultant payments, free use of equipment is a big one. Free or reduced rental payments, right? So, waivers of gifts or things like that. Fancy dinners, vacations. We've seen golf trips, seen sports tickets. A verdict was just given in a case this week on that had some of those. We had a recent settlement only a couple of years ago where the form of remuneration from the company that violated the anti-kickback statute was advertising. That was the local advertising done in the local press, local written and radio press. That was the form of the kickback to the healthcare practitioner from the company that was violative of the anti-kickback statute and resulted in a fairly big settlement from our district. So in terms of this, I think for practitioners such as yourselves and those who are here, I think that from the government's enforcement perspective, the message would be, exercise caution in the things that are offered or granted, and you have to, at each level in this very heavily regulated area that all of you are familiar with, these are risk areas because there are a lot of costs that go into this. Maybe, certainly a doctor can intend nothing wrong and not have this ill intent, but if you go into it understanding that it's a statute that can operate in both ways, maybe you intended nothing wrong, but a consequence of somebody else doing something wrong is that you become a witness in that case. And it's not really fun. It's not really fun to have to sit down with an FBI agent or a federal prosecutor and have to answer questions. So I think in terms of our kind of message, in addition to seeing something and saying something, as Agent Gardaki said, I think part of my suggestion to folks would be know your risk areas, where, sales rep, obviously you guys can have interactions with all sorts of companies all the time. But, knowing the risk areas, where, a sales associate or a sales representative and a healthcare practitioner end up, coming into contact is something that does carry a degree of risk. Depending on what's done, what's said, what's exchanged. And so, it's something to be mindful of in terms of, your own practice, and how you want to, account for things and how, what your hospital's policy, what your own office's policy is. Obviously it's not for Agent Gardaki and I to kind of give you advice on the best ways to manage those risks. But I think there are probably other lawyers out there that you come into contact with that would answer those questions if you have them.
I have a question that I'll paraphrase from the chat group here, and then maybe we can wrap up with some concluding remarks if that's okay. So the question really is about the fact that as providers and as hospital organizations, we have a massive increase in the amount of electronic medical records that we're using, relying on. There's much more compliance-based that we're doing in the university setting and large practices, HIPAA compliance and so forth. But at the same time, there is a climate of lower reimbursement, physician burnout, hospital margins are very thin. So have you seen trends in increase in fraud and abuse in healthcare, or has it gone down with these safeguards that we hear about and that are coming through from the IT sector? And if not, how do you reconcile the fact that we have more safeguards, more, we think, improved technologies to improve, healthcare delivery and reduce fraud, but necessarily more fraud that's increasing? Is that related to the initial points that I brought up with low reimbursement and burnout? Just to paraphrase the question. Thank you.
So, I don't have a great answer to that question because it's hard to account for physician burnout and lower reimbursement rates from my perspective. What I can say is that, our two offices have devoted, over the last decade or so, having devoted enormous resources to this area of enforcement. And with respect to the District of New Jersey in particular, I can say that that Medicare costs, like the absolute measure that we've seen, we have seen reductions in those, and so we do get a great amount of data in this space, and so we'd like to, it's hard to make a causal determination as to this, but it does seem, suggestive to us, at least, that our enforcement efforts, at least in New Jersey, have worked have done some work. I think, Dr. Wyman cited that large number of recoveries. I feel like we have, done a lot of, done, pretty effective job in terms of these things. Overall, is compliance better? It's hard to say. I think that, part of it is what you guys experience. If if you feel like you're experiencing a more rigorous culture of compliance, and that, things like electronic medical records, which I think are a very good thing, are on your day-to-day, day-to-day business, making the things more, easy, capturing, what you are, doing, capturing your treatment records and what should be billed in a more accurate frame. I think then that is going to bear out. And I think just on a, a macro level, in terms of like we've talked about how intent matters. I think, being able to show like, man, my practice has this kind of rigorous level of like, doing records, following through, following the rules, following the procedures. Well, to my mind, even if there are, errors there, that to me is a lot, from an enforcement perspective, that's a crappy case, right? Because you've got a doctor who's been, doing things by the book, as opposed to, nah, we don't really pay any attention to that. Like, I just write the record and send it off, and who knows what happens next, right? Like that to me is where, where it's a lot more compelling. Mary, I don't know if you had anything.
Or practices where there are no records, or very minimal records, right? And I see some sort of smiles, right? But those practices still do exist, right? And people are motivated by different things, right? They have different situations and different stressors going on in their life. And at the end of the day, physicians are people, right? They have the ability to make a choice, and what they choose to do is up to them, and is affected by a variety of different things going on in their life, right? But needless to say, there is a lot of job security in working healthcare fraud investigations, unfortunately, because while someone might be a good person intrinsically, sometimes they do make very poor decisions.
See
That's
a lot electronic.
disarming last concluding remark from you, as Special Agent. But thank you so much for the both of you agreeing to be speakers tonight. It was a very insightful and educational lecture for all of us. We appreciate you guys spending the time with us, and I appreciate the panelists also. And I'm thankful for those who joined as guests. We had some leadership from our Eastern Society, past presidents, and so forth. So I'm grateful overall for the turnout and for the event tonight. And again, thank you so much. Any final comments?
Just thank you again for inviting us and for choosing to spend an hour and a half of your very precious busy time exploring this concept. I'm trying to get out in front of it because as most folks probably have experienced throughout your career, they don't teach this at medical school, right? And I'm not certain how well it is touched upon in any type of continuing medical education that you all do. So very important and insightful. So thank you.
Thank you so much.
Yeah, I agree. Thanks so much. Look, you guys are, your day job is pretty, is very, very important. Like we really appreciate that, all the things that we were talking about are like on top of your day job, which is, like treating people and making them better. So that I think, we're mindful of the space that we're in, that even though we're, we deal with kind of, the law breaking side, that, obviously the commitment of physicians like yourselves is kind of the most important part of the system. So we're mindful of those things, but and really appreciate you guys, devoting to some of your day to these concerns and hearing from us. So thanks a lot.
Thanks again, everyone. We're at the end of our
Thank you.
really great webinar. Thank you, Aviana. Thank you to the society for giving us this time and sponsoring this and helping us with the planning and getting the word across. Thanks again so much, everyone. Good night.
Thank
Thanks
you
so
all.
much.
Good night.
Good night.
Thank you.